I want to thank all of you. Many of you on this call right now have already donated generously to Romero, and it really makes a difference, whether it's a one-time donation or a recurring sustaining donation. And for those of you that are on for the first time, you can go to romeroinstitute.org. You can check everything out on the Lakota Law Project and California Green New Deal, Green Power, history of Danny and his wife, Sarah Nelson. And you can push on the give button and donate. Welcome again, Danny, to the living room. You're going to be speaking on Donald Trump's threat to regulate Twitter, the issue of federal or state government regulation of the content of media, Twitter, the internet, Facebook, or other media for truthfulness, public safety, or public health. And of course, any other update you want to do on Lakota law or green power issues. Welcome, Danny Sheehan.
Yes, Danny.
Okay, so a week ago, our Romero Institute, Lakota People's Law Project, filed our amicus brief with the United States Federal District Court in Washington, D.C., in the Dakota Access Pipeline case. In our amicus brief, we asserted that the failure of Judge Boasberg, the federal district court judge, that's been sitting on the major federal lawsuit that was filed by the Lakota tribes back in 2016 to try to get an injunction to stop the construction of the pipeline under the Lake Oahe and under the Missouri River, their sole source of fresh drinking water, and the source of drinking water for tens of thousands of people downstream from the reservations, should have been stopped until such time as the Pipeline Corporation, that's the Energy Transfer Partners, and the U.S. Army Corps of Engineers of the Trump administration undertook and filed a full environmental impact study. The court, Judge Boasberg, consistently refused to grant them a temporary restraining order, allowing the construction to begin under Lake Oahe and the river without compliance with the Environmental Protection Act, arguing that he thought that the deficiencies in their original filing under their environmental assessment could be cured fairly easily. And then when they finished the construction and wanted to open the pipeline, he allowed them to open the pipeline, arguing that even though they had not yet sufficiently addressed the deficiencies in the environmental assessment, he thought if given a little bit more time, they could do it. And he allowed them to continue going forth. Then they moved to start pumping oil through the pipeline, 910,000 gallons an hour through the pipeline. The Lakota tribes pointed out in their briefs being filed by the Earth Justice public interest law organization that the detection system for leaks in the pipeline couldn't detect anything from 1% or below, which means that 910,000 gallons an hour going through the pipeline could be leaking as much as 9,000 gallons an hour into the lake and into the surrounding area, and they wouldn't even be able to detect it. But still, Judge Boasberg refused to stop the flow of oil, allowed it to go forward. It wasn't until the middle of last year, in June of 2019, the Circuit Court of Appeals in Washington, D.C., entered a ruling in another case that related to the U.S. Army Corps of Engineers, pointing out that what they were doing in that other case, which was generally the same thing they were doing in the Dakota Access Pipeline case, was insufficient, and therefore struck down a permit that the U.S. Army Corps of Engineers had granted for another pipeline. Because of that, Judge Boasberg had to scramble and basically reverse his position that he had been taking for 3 years. And he agreed that their original environmental assessment was not only insufficient, but it was fatally insufficient. And therefore, it was not going to be able to be cured. And they had to undertake a prolonged environmental impact study which could take anywhere from a year to 18 months or more. But he still refused for a third time to stop the flow of oil through the pipeline. And he asked for briefs. And the Earth Justice people were scheduled to file their brief on the 20th of May. We filed our amicus briefs on the 20th of May. And what we argued is that the test that Judge Boasberg had been applying, that came from an earlier 3-judge panel ruling of the Federal Circuit Court of Appeals, all right-wing, Reagan, Republican appointed judges, stating that even when the U.S. Army Corps of Engineers has failed to meet all of the standards of the Environmental Protection Act, still the courts should have a right to balance whether or not letting them to go forward to build and put the pipeline into operation would impose greater economic burdens on the corporation than the real danger that was being posed to the people. It basically gutted the entire purpose of the Environmental Protection Act. And yet these 3 right-wing Republican-appointed judges had years earlier entered this 3-judge panel ruling, giving the major corporations one more bite at the apple, basically throwing it up to judges to just balance the interests of the corporation versus the environment and come out with whatever type of a decision they wanted. We argued in our briefs that if Judge Boasberg, were to apply that standard in this case, then the case would have to be reversed. The previous circuit court would have to be reversed, and that we would take steps to bring the case before the full circuit. And we pointed out that there was another case presently being evaluated by the full circuit, which was analogous to this. So anyway, we have filed our amicus brief. They have it in front of them now. The Oil Corporation and the U.S. Army Corps of Engineers filed their briefs this last Wednesday, just 2 days ago now. And so that the issue's before the court right now. And we are in the process now at the Romero Institute in our Lakota People's Law Office. We are putting together a major videotape of the interviews of a lot of the witnesses that we were prepared to call in Chase Iron Eye's defense, arguing why he had to take the action that he did to mobilize the Native community around North America and bring them to the site to hold a prayer vigil in the pathway of the pipeline, because the judicial relief that was being made available through the federal system was completely malfunctioning, in that it was not granting the type of relief that was intended by the Environmental Protection Act. And so that he had, by necessity, to undertake the kind of direct action that they undertook. And we asserted that as a defense. We had a whole panoply of witnesses that we were prepared to present to the court. And of course, on the eve of the trial, they dismissed all the charges against Chase Iron Eyes to prevent us from putting this case on. So what we've done is we've interviewed all of those witnesses, and we've put them together in a videotape now. That we're going to start rolling out a sequence of videotapes while this case is under consideration by Judge Boasberg, making it clear to all the people in the country what the evidence is that would require the shutting off of the oil in this pipeline. So that's the update on that. Now, with regard to the Keystone XL pipeline, you know that the Cheyenne River Sioux Reservation and the Pine Ridge Oglala Sioux Reservation have put up roadblocks to prevent traffic from coming into their reservation territory during this pandemic. And the oil corporation has been complaining because they are arguing that this is an attempt just to block their vehicles from coming through the roads to help build the pipeline. The fact is, there's an outstanding injunction against them, prohibiting them from engaging in such construction, but that's up in Montana. And they think that perhaps they can, down in South Dakota, they can continue trying to build the pipeline down there. And so these safety inspection stations are now in place, and the governor has decided that she's going to challenge this legally. She's contacted Attorney General Barr in Washington, D.C., and has asked for federal assistance in taking down these roadblocks. And so that's going on right now, but the checkpoints. But the bottom line is that there is an outstanding federal court injunction that's been imposed by the federal judge up in Montana, prohibiting any construction on the entire pipeline, including down in South Dakota. So, so that there's good news going on all around, even though it's taken a long time in persistent efforts on the part of the indigenous people and the Lakota people in the Dakotas to oppose this, along, of course, with tens of thousands of allies, non-native allies, but representatives from over 200 tribes from all around North America have come to the site of the Dakota Access Pipeline to stand with the Lakota people to oppose that pipeline. So as of right now, there's an outstanding injunction prohibiting further construction on the KXL pipeline on the western boundary of the Lakota Territory. And there's a federal court now considering shutting off the oil flow through the Dakota Access Pipeline along the eastern boundary of the Dakota Territory. So both of those are very good news in that area. In the midst of all of this other bizarre stuff that's going on right now about the pandemic, what we want to do tonight is I want to address one of the issues that has arisen in the context of this pandemic. Now, we didn't know, for example, that there's been a major controversy that has arisen over people who don't believe the federal government, and they don't believe the CDC. They don't believe the agencies that were asserting that this is a terribly dangerous virus. They've asserted historically that the fatality rate for this virus is being dramatically overstated. They have stated that the contagion level is way lower than has been asserted, based on the fact that so many people get it, but it doesn't have any symptoms. And that they're arguing even that a lot of the deaths that have been attributed to the virus are being misrepresented. The various hospitals are falsely reporting some deaths as being a consequence of the virus, whereas they've died from something else because they want to get money. And what's happened here, and it comes to the subject that we're going to be discussing tonight, there's been a major outcry on the part of primarily the liberal and progressive community against these people broadcasting their arguments about this being a hoax, about there being some sort of conspiracy going on the part of the pharmaceutical corporations to compel everybody to get a vaccination against this virus. They've come out, it's brought in the whole controversy over whether vaccines are dangerous or not. And there's a lot of people that have been demanding that the people that are opposing, as they put it, opposing vaccines should be cut off from the internet. They should not be allowed to put up information on YouTube. They should not be able to put their information out over the internet, over Google, over Twitter. They ought to be stopped. And there's been this significant movement within the more or less liberal community in the country to demand that Google and Facebook and Twitter and the other major media censor these people, to keep them from putting out this information, which they believe to be wrong and knowingly wrong on the part of the people saying it. So what they're basically proposing is that there be censorship being exercised by the major corporations, such as Google and Facebook and Twitter and YouTube and others, to censor these people whom they believe to be saying things that aren't true and are potentially detrimental to the public health of the community. Now, this is a sort of second cousin to a series of other demands that have been being made, surprisingly enough, by the liberal community, that certain types of speech not be allowed on the internet. They argue that hate speech, speech that directs kind of negative statements about whole racial groups or ethnic groups, including, for example, people who deny the reality of the Holocaust, should not be allowed to have access to the internet. They should not be allowed to say things like that. They argue that there are certain things that are so obviously untrue and that are directed toward ethnic groups that are protected in a special way because of their racial and ethnic discrimination that's been displayed against them historically, that people should be prohibited from saying things adverse to these people. This has gone back to some time where the people have argued that the Ku Klux Klan, for example, should not be allowed to march. They should not be allowed to march down a public street like war protesters are allowed to, or women's rights groups are allowed to, or gay groups are allowed to. But yet, strangely enough, people in the progressive community and liberal community will say, yes, but not the Klan. They can't be allowed to march down the street and be advocating racial discrimination against Black people. They can't be allowed to march down the street and have signs or make public statements that are derogatory toward Jewish people. And so this peculiar phenomenon has arisen where the liberal community that is usually the major champion of free speech, the major champion of fundamental rights that are set forth in the Bill of Rights, and indeed usually favoring and championing an entire panoply of natural law rights that individuals have over and against the state, find themselves, or we find them in a very peculiar position here, where they seem to be advocating censorship. They are making demands that the state legislatures, even the federal legislature, and executive agencies such as the Federal Trade Commission, the Federal Communications Commission, and others take steps to restrict access to the internet for these people. Now, we see the major corporations such as Google and Facebook responding to this public pressure to actually do things like, for example, they've taken Alex Jones off the internet. They will not allow Alex Jones, whom I personally consider to be a total maniac, saying really bizarre and outrageous things. But on the other hand, I think the same thing is true of Rush Limbaugh, and I thought the same thing was true of a number of other people. But I, as a constitutionalist, am extremely concerned about this whole idea that the media are somehow being pressured by people to stop other people from saying things which they don't like. Now, as a matter of full disclosure here, I need to point out that I have actually litigated a number of issues having to do with this. Back in 1972, I represented the New York Times in a major litigation where the Jewish Defense League, Meir Kahani's group, rampant Zionists, filed a petition. They sent a full-page ad to the New York Times, just excoriating Leonard Bernstein, the head of the New York Philharmonic Orchestra, for his having given a campaign or a contribution to the Black Panther Defense Committee. I happen to have been helping in some small way in the Panther Defense, the Panther 21, back in 1970. And we were providing this defense, which, by the way, after an 18-month trial, took the jury less than 15 minutes to acquit all 21 defendants on 157 separate criminal charges. So it was a perfectly legitimate defense and an extraordinarily important defense to protect a very unpopular group, the Black Panther Party, against a police and district attorney conspiracy, basically, to prosecute them and try to destroy the party. But Leonard Bernstein had sympathetically given a contribution to that defense team. And so the Jewish Defense League had sent a check in with a full-page ad to the New York Times excoriating him for having done that. The New York Times chose not to publish it and sent them back the ad and sent back their money. Jewish Defense League, represented by Roy Cohen, I might add, filed a lawsuit against the New York Times, and I was assigned by the Cahill-Gordon law firm that represented the New York Times at the time to represent the New York Times. And I wrote the briefs and thoroughly researched the issue, pointing out that the New York Times and any other First Amendment platform had a right to turn down any statement or speech that they felt like. They could publish basically anything they wanted to. And as you recall, I had actually represented them as well in the Pentagon Papers case, saying that they had the right to publish even top secret national security information. They have the corporations that are actually publishers have a right to publish anything they want and a right not to publish anything they don't want to. So that's an important principle that I have stood for in the past on both ends of the spectrum, the right to publish anything they want to, even in the face of a government demand that they not be allowed to publish national security information. And on the other hand, to not publish the full-page ad from the Jewish Defense League because the New York Times chose not to do that. So I have argued all along this spectrum, but the principle is still the same, and that is that a publishing platform or a publishing entity such as the New York Times, the Washington Post, NBC, CBS, ABC, CNN, MSNBC, Fox News, much to a lot of people's chagrin, are allowed to say anything they want to. The reality is you don't have to watch it if you don't want to. You don't need to tune in on it. And if you get upset over the fact that half of the people in Kansas, for example, are watching Fox News all the time, and it makes people in Kansas think all kinds of things are true, which you don't believe are true, which may not even be true. It still does not justify attempting to recruit the United States government or state courts in any way to intervene and try to punish them for publishing something or not publishing something. This really amounts to a very, very important principle here. And that is the Constitution has to do with the exercise of government power. Because of the history that we have all gone through, not all of us, the Native American people were here for 10,000 years before any of the Europeans came over here. But when the Europeans came over here, especially the people from England in that whole area, and brought with them the common law history of the English people, English-speaking people, they brought with them certain traditions. And that was that they had developed an entire set of principles to trying to restrict the exercise of the power of the kings. And not just the kings, but the royalist elite in Europe, of the royal families and the aristocracy that basically plied their trade to the detriment of the vast majority of the people, imposed unfair taxes on them, burdened them by taking portions of their crops away from them in exchange for purported protection, usually protection against their own royal forces. And so because of that, there's been this really deep-set resistance on the part of American citizens to the exercise of state power or government power. Can I get a drink of water? I'm sorry. But as I pointed out in our discussions before about this, there was this major tension at the point of the creation of our United States Constitution between two very specific elements. And you'll hear me repeat this over and over again because it's such an important principle for us to understand. that there were two very distinct communities, different communities that were involved in the crafting of our United States Constitution. On the one hand, there were the elite, aristocratic, financial interests, the commercial interests, business interests that, in fact, actually are the ones that instigated the revolution against King George and England, because they were really upset. Remember, taxation without representation, the tax on the tea, commercial tea that was being sold in the colonies. It was the commercial interests that really mobilized and organized people to rise up against the British Crown. But what they did is they mobilized and recruited the peasantry and the farmers and the rural people, I guess you'd say the non-mercantilists. They recruited them by expressing all types of principles that had to do with equality and democracy and the right to be free from aristocratic rule, etc. But once they accomplished their breaking away from England, there was a group of people in this commercial class, this financial group of people that did the banks and the privately owned businesses, etc. They began to form their own type of aristocracy. They're kind of an elite group. They were well educated. They owned more property, and what they did is they basically started enshrining in the Constitution, or demanded to enshrine in the Constitution, certain privileged authority on their part. For example, as people may recall, we still live with the fact that we American citizens are not allowed to vote directly for the President of the United States. All we can do is vote for electors that are then sent to Washington to engage in the Electoral College and to choose who the president is going to be. In the same way, at the beginning, we weren't allowed to vote for United States senators. The United States senators were all chosen by the various state legislatures, or the legislatures of the colonies that became the United States states. So that elite were the people they called the Hamiltonians. They were represented by Alexander Hamilton, who was a lawyer that represented the commercial interests in the crafting of the United States Constitution. On the other end was the group of people who were led by, actually, James Madison. They're often referred to as Jeffersonians, but it was Thomas Jefferson, Aaron Burr, and very importantly, James Madison and others. And as it turns out, that most of those, not Jefferson, but Aaron Burr and Madison and the others, they all happen to have been schooled at the College of New Jersey. And they were taught moral philosophy by a professor by the name of John Witherspoon. And John Witherspoon actually taught not only James Madison, who was the principal architect of the Bill of Rights, but also Aaron Burr, who happened to be the man, as you'll recall, who actually killed Alexander Hamilton, who was the spokesperson for the aristocratic financial interests. That's how intense that tension was between those two groups at the beginning. But what I'm saying here is that this tension between the people who believed in natural law rights that belonged to the individuals, the Madisonians that had been schooled by John Witherspoon, who taught them this moral philosophy. It's basically theological in its roots. It's a natural law concept of fundamental rights that inure to an individual human being by dint of their humanity, actually by dint of their possession of a faculty that is able to directly experience the unitive phenomenon that bonds the entire universe together into a unified harmonic whole, but which corporations, by the way, cannot do. They don't have this faculty, but this is a faculty that human beings have, which give us a perspective from which we can exercise free will. And that has to be protected. Our ability to speak, our ability to read what we want to read, to think what we want to think, advocate what we want to advocate. Though that's a set of fundamental natural rights that are in order to individual human beings. And the challenge is that they are usually we are usually exercising those rights in opposition to the elite, this aristocratic, financial, commercial elite that are attempting to basically maintain an aristocracy, just like ruled in Europe. But that's why 1% of the people, in the United States, own, 75% of all of the wealth, and that they're the ones that are behind the scenes pushing to get certain legislation passed, which tends to benefit them. Like 87% of all the members of Congress are lawyers, and they tend to do the bidding of the major corporations that pay for their campaigns, and so that there's this tension that goes on. And so there is a tension that lies beneath the entire First Amendment, that the First Amendment, which is the first of the amendments that were attached to the original Constitution, we know that the Constitution originally was drafted and passed in 1789. The Bill of Rights was enacted and attached in 1791. And they were the full manifestation of each of these two respective groups, the two groups that were involved in crafting the Constitution and striking certain types of compromises with each other. Now, all of that is by way of saying that the fundamental underlying principles of the First Amendment exist because the natural law school advocates, the Madisonians, were insisting that the citizenry had these rights over and against the state. And there is some bit of confusion here because the elite commercial mercantilists that were represented by Alexander Hamilton and the financial interests, it developed eventually during the robber baron era into the corporate executives. They created this new business vehicle called the private shareholder-owned corporation. And what happened is that the former aristocratic elite financial and mercantile class became the corporate capitalists that basically dominated all of the economic fields, that took over all the railroads and all the agricultural centers, the manufacturing, the steel production, the shipping lines, et cetera. And so that you got this conflation of the capitalist financial industry with the aristocratic families that had been powerful and wealthy and landowners early on. And so that the exercise of the First Amendment was a tool, a weapon, a resource that the regular people had to assert their right to participate in a democratic decision-making process in our country. Whereas the mercantilists and the financial elite and the corporate elite, they thought that they should be the ones that basically run the government because they're smarter, they've got more money, they've got more power, they tend to be better educated, and they're genuinely convinced that they are more entitled to rule. And they're basically in some significant tension with the entire principle of democracy in our country. And so that usually the champion of free speech and free press are in fact the plebeians, the regular people, not the elite, not the corporate power. Not in what's happened now in this peculiar state that we're in right now. For basically 225 years, the only corporations that were basically in favor of free speech were the press, the newspapers, and the radios, in early television. They were the ones, they were companies, they were actually business corporations, but they were advocating free speech, the maximization of free speech. The only caveat you'd have to put on that, which is not an unimportant one, is that after the Depression of 1929, what happened is when Franklin Roosevelt was elected in 1932, he began to try to implement a whole series of federal statutes that restricted the unbridled power of corporations that had risen to power during the robber baron era, from the end of the Civil War in 1868, basically up to 1898, with the ascension to power of the McKinley administration. That whole taking over of all of the instrumentalities of government on the part of the rich financial elite corporate owners and families that own the majority of the stock in these major corporations, that came to full fruition and resulted in the 1929 stock market crash, because they were bleeding the country dry and taking all the resources for themselves, and putting regular people at almost in a state of slavery, of like 18-hour work days, 7 days a week, with children working in the mines, women being given 2 separate bathroom breaks all day, working in the textile mills and in the sewing shops, the sweatshops. That it was Franklin Roosevelt that between 1932 and 1934 that began to implement a whole series of federal statutes to try to rein in the power of these corporations. And the corporations started insisting that their constitutional rights were being violated. They kept insisting that these laws that were being passed violated their right to the due process of law. They wanted to be able to say anything they wanted to in their advertisements, and insisted that was considered to be free speech, and insisted that they were entitled to be considered persons in the eyes of the Constitution. And this was now being argued on behalf of the mercantilists and the elite aristocrats in the country. And Franklin Roosevelt came in and said, no, you're not people, you're not entitled to these constitutional rights. And there was a huge showdown that took place in 1934 between the Roosevelt administration and, very importantly, a significant number of these elite families that were part of the partners, the clients of Brown Brothers Harriman, one of the big private financial houses, actually tried to mount a military coup against Franklin Roosevelt. A lot of people aren't aware of that, but the DuPonts, René DuPont, J.P. Morgan, some of the Rockefellers, there were a number of those people that were business clients and partners in Brown Brothers Harriman, private investment firm, that actually tried to mount a major military coup. They tried to get the commandant of the United States Marine Corps, General Butler, to man up and put together a force to overthrow the Roosevelt government. And that's been suppressed in history, but it's true. So this tension that exists between the elite corporate owners and the mercantilists in the financial community, this rich 1% that we hear about so much, have not historically been fans of free speech except for themselves. And they've been part of the people who run the government, and the government of the federal government and state governments, much like the kings of Europe who are in charge of governing, view the First Amendment to be anathema to them. That it is constantly being used by the great unwashed to challenge them, to call out against their injustices, to try to organize among themselves to oppose them, to try to apply economic and political pressure to carve into the kind of monopoly power that the elite and the aristocratic classes have. And so the bottom line is that we have a very peculiar situation that's arisen here, where some of the most powerful and influential corporations now in the country are these media companies like Google and Facebook and Twitter. And here you have these corporations that are very powerful, but they are playing the role of traditional media in press. They are providing a platform in which millions and millions of people now have access to open communications, where they can reach out across the country, indeed out across the world, and express themselves and help organize among themselves people who share the same values and stuff. And so it's happening right from the very beginning. There's been a great deal of concern on the part of the aristocratic ruling elite in the United States, the major owners of corporate capital in the United States, about this internet. And you've seen moves made, for example, in China and in Russia and other places, authoritarian governments in North and in South Korea, that they've moved against the internet to restrict access to the internet. They don't allow the internet to be used to question the government, to criticize the government. They don't allow people to express opinions that the government doesn't approve. And so you can see that the natural tendency of governing structures are just exactly like the founders of the Constitution, mainly the Madisonians, pointed out, is you have to be suspicious of the exercise of state power on behalf of the instrumentalities of the state. And so the First Amendment and the Bill of Rights has been enshrined to protect our ability as regular citizens to speak out against state power, to speak out against major corporate power, to criticize those in positions of power in governance. And so that the danger of the internet from the very beginning has been twofold. One is that the governing powers would attempt to get control over the internet and start to censor it, to keep people from saying things to each other on the internet that the ruling elite don't want talked about, which usually has to do with criticizing them and their instrumentalities of government that they have created and put in place primarily to foster and promote their own financial interests for the most part. We, as the great unwashed, the paysans, that we have struggled over 250 years now to get democratic access to the tools of government to try to actually bring to fruition the promise of democracy, to actually make the instrumentalities of government function on behalf of the vast majority of the people, not on behalf of the wealthy and the elite. And so this struggle has been going on now for 250 years. And so what we see happening now is that there's been this looming danger ever since the onset of the internet. And we have to remember that those of us who were in the baby boom generation remember when we didn't have the internet and we didn't have Google and we didn't have, people spend half of their time arguing about facts, fighting and arguing about facts. Now, all you have to do is take your phone and flip it open and say, let me see, what are we arguing about here? What was the year in which Columbus discovered came to North America? Oh, look, here it is. You said it's 1450. Somebody else says it's 1480. Someone says it's 1492. Let's look it up, okay? And so there has begun to develop a source for the resolution of factual dispute, which the internet has now started to become. In Google, in Wikipedia, and other companies, private companies, almost like the Britannica that prepared the original Encyclopedia Britannica, that has actually taken on in a corporate way, providing factual information to the people. And they've become extraordinarily important to the people. And now what's happening is the elite, the governing elite, are getting concerned about this, because you've heard the conversations just as recently as last night in Minneapolis. The people on the television, the CNN and MSNBC that were covering the live demonstrations of the people torching the 3rd Precinct police station, where the 4 police officers came from that killed Mr. Floyd, there was this constant discussion about, oh, look how all these thousands of people showed up all of a sudden. I guess it was the internet. I guess they were on the internet and on their cell phones organizing each other and calling each other out to participate in this demonstration. And you can see, therefore, that the people that are in positions of power are concerned about this particular tool that exists now in the hands of the people. And so we have to be extremely concerned right now that any steps that are being taken by people in position of political power to restrict in any way the absolute unbridled right of these platforms to publish any information that they want to publish has got to be protected. And that's a very simple proposition to protect, because it's important to remember that the House Un-American Activities Committee that just laid waste to the liberal and progressive community for a full decade in the 1950s, was originally created to allegedly go after fascists. That was the actual purpose of the House Un-American Activities Committee. And yet they spent 99% of their time coming after liberals and progressives, and eventually anybody who read more than 2 books a year, and so that they went after their enemies with that kind of power. And the first thing that one is taught in a constitutional law course is that you have to develop an instinct for distrusting government, constantly challenge them, put them to their test, make sure that they're not trying to get away with something, make sure that they're not either corrupt or working on behalf of some minority elite, because that's been the history of governing structures down through all of Western civilization, and to some great extent in Eastern civilization as well. And so what I'm saying is that this particular situation that we're confronted by now, of Donald Trump deciding that he is going to wade in on these internet companies, that he issued an executive order just yesterday, May 28th, an executive order in which he has asserted, this is a copy of it right here. This is a 4-page. Can you see? I don't know. Right here. I don't know. You can't see it, I guess. But it's a 4-page executive order in which he is. He obviously he didn't do it. I mean, he doesn't. We're lucky if he can write a full paragraph. But the bottom line is, it's clearly William Barr and the people in the Justice Department, these right-wing people that he's brought into the Justice Department now, have drafted this executive order in which what they're doing is they're threatening Google and Facebook and Twitter and the other internet thing, YouTube. They're threatening them that if they attempt to restrict or exercise their discretion to put tags on Trump's tweets. This is how it happened. What happened is Donald Trump last Tuesday, this past week on May 26th, he sent out a tweet that said this. He said, "There is no way, zero, that mail-in ballots will be anything less than substantially fraudulent. Mailboxes will be robbed, ballots will be forged, ballots will be illegally printed out and fraudulently signed." He said, for example, the governor of California right now is sending out millions of ballots to people for mail-in ballots to everyone living in the state, no matter who they are, no matter where they came from. He says that will, what do they say, or no matter where they came from, that they will all get one. And that will be followed up with professionals telling all of these people, many of whom have never even thought of voting in the past, how to vote and for whom to vote. This will be a rigged election coming up. No way am I going to allow that, he said. And what happened is Twitter put an attachment on his Twitter saying, this isn't true. By the way, here, look at the following articles that people have written that have demonstrated there's no substantiation whatsoever for what he's saying. And he went ballistic because it's interfering with him being able to propagandize all his followers, the 18 to 20% of the people in the country that are the people that Abraham Lincoln once said, you can fool some of the people all the time. That's the people. And so he was really upset about this. And so he has now issued an executive order, which they've been drafting for some time. This was not an overnight draft that happened here. This is a long 4-page draft. And what they've done is that he has now issued an order. Now, the reason that this is a little more complex than you might think. This isn't just a big order saying the United States government is going to come in and regulate the internet and is going to tell them what to say and what not to say. What he's done instead is there's a substantial challenge that that the internet has. YouTube and Google and Facebook and Twitter, these platforms, to the extent to which they are republishing statements that are made by the citizenry. There is a law, there is a major caveat on the First Amendment. I don't happen to agree with it, but it's been systematically supported down through the years that say that a court, after the fact of a speech, after the fact of a statement, can entertain a lawsuit against a speaker if they have libeled or slandered another person. And that ever since the founding of the country, this has been viewed as a legitimate common law right that a person has. If they've been libeled or slandered by someone else, you can go to court, and under the common law principles of libel and slander, you can sue them in court, which is a state agency, of course. And so therefore you're invoking the power of the state to punish the person who has libeled you or slandered you. Now, there are very specific criteria that need to be met in order to prevail on a libel or slander case. And you have to prove that it was wrong, what they said, that they knew that it was wrong, that they were saying it out of malicious intent, and the intent was to damage you and your livelihood, et cetera. There are standards that have to be put in, but you have this peculiar exception where a state or federal court, state court in this mostly cases, have a right to inflict a money judgment against you for your speech. And it's the only caveat. Now, because of that, these platforms such as Twitter and Facebook and Google and YouTube, when they republish something that a citizen has prepared and sent to them, they could be held liable for republishing that if in fact it is libelous under the law or it represents slander. And therefore, these corporations, the major media corporations, reached out to Congress to get them to pass a special statute preventing them from being held liable for the content of what they were merely republishing and providing a platform for people to talk to each other. And so there is a federal statute that is called the Communication Decency Law. And the Communication Decency Law acts as a federal statute that actually provides unique protection to these particular platforms, these electronic platforms in the internet, immunizing them against libel and slander suits for things that they simply republish because they didn't want them in the business of censoring and making substantive decisions about content. And so this statute exists. Now, what Trump has done is in this edict that he has put out, he has said that he is going to direct the Federal Communications Commission to exercise its power to basically interpret Section 230 of the Communications Decency Act to take away the protection against libel suits for any one of these internet groups that don't abide by a whole series of rules and regulations, which he and William Barr have promulgated in these 4 pages here. And you can find it on the internet right now. If you just look for the May 28th presidential executive order by Donald Trump, and you'll find it, all 4 pages of it, and you'll see all these restrictions. And he's gone on and on. And knowing Trump, you could expect this. He's whining about himself, and he said, Twitter is now selectively deciding to place a warning label on certain tweets in a manner that clearly reflects their political bias. The Twitter seems never to have placed such a label on any other politician's tweet other than me, he's saying. And as recently as last week, and catch how dangerous this is, Representative Adam Schiff was continuing to mislead his followers by peddling the now disproved Russian collusion hoax. And so what he's doing is pointing out that what he really wants is that those corporations to not be allowed to republish things like that. That's what he's after here, okay? And he puts it right in front of you in this edict that he's done. So I've done my 1 hour of laying the basic issues out here. But let me just say in conclusion, before we start having questions and answers here, that everybody who's listening needs to just take a stand on this and prohibit any restrictions whatsoever on the internet. Now, some people are going to disagree. They're going to say, but what about the people that are opposing vaccines? They're a threat to the public health. What about child pornography? What about obscenity? What about, and they'll start going down the list. The answer to that has always been, you don't have to listen to it. You don't have to watch it. The internet now has like 20 skrillion different channels of things that you can look at. You don't have to fish in on these things and look at them. Now, if you're disturbed that other people are looking at them and they're coming to believe things that you don't believe to be true, that's what democracy is about. What's happened here is this particular technology now has magnified the megaphones pursuant to which people can express their own views. And you may think it's dangerous, but what you're going to discover is that you are finding yourself sympathizing with the elite. You don't want people saying things that you don't like and that you disagree with. And you are actually in danger of going to the ultimate point of pointing out that I am declaring that what they're saying is not true. And therefore, they don't have any right to say it. The problem that you have to understand is that you're invoking state power. You're invoking state power to intervene to determine what is true and what is not true. And you may be perfectly happy so long as they are exercising that state power in a way that agrees with what you think is true, and then just stopping people from saying things that you believe are untrue. But I can guarantee you, that within minutes of them securing that power, they're going to go after the people who are criticizing the powerful in the elite. The aristocratic elite that own the corporations and own the banks. And they're going to close in on us. And they're going to try to shut off the internet from us, using it to organize, using it to educate people, using it to mobilize people to protest against unjust exercises of power. And so what I'm saying is, everybody in listening range of this discussion tonight has to follow the rule: do not let any government power limit what it is that can be said on the internet and any of these media at all, okay? And even if there are things on there that you don't like, that's they say you don't have to listen to them. And you are perfectly free to broadcast opposing views. And you can marshal your information and your evidence against them. And what you're going to have is a robust and intense conversation about these things. And that's what we need to do. And that's why our conversations every other Friday night here are going to be raising these issues with us. We can talk about them. And what we do at the Romero Institute, for example, and with our Lakota People's Law Project and our Green Power Project, we reach out to the people to try to educate and mobilize the people to undertake action which we believe is in the public interest. We believe that the Green New Deal that we're drafting right now is very much in the interest of the vast majority of people, not only the people in the state of California, but the people in the country and the world, to protect our planet against global climate change. Now, we know perfectly well that there are a whole bunch of people who are going to insist that the whole global climate change issue is a big hoax, that it's not true at all, that there's no connection between the carbon that's being put out by major corporations and the impact on the climate. They'll have sophisticated arguments. Oh, look, it's sunspots, or this is just like we go through, our planet goes through these cycles where you have ice ages and periods of high temperatures, et cetera. They're going to say things like that. But I can tell you, if you are a genuinely progressive and liberal person, you cannot reach out to seize control of state power to crush and stifle those types of expressions. Our job is to simply articulate the truth. Our job is to utilize the tools that are available for us, keep them free in Twitter and Facebook and Google and YouTube, keep them free so that we can put out our information. We can use all the data and use our intelligence, use our education, use our ability to marshal facts and reach out to try to help our people understand what's going on and mobilize the people to vote. Vote by mail, hopefully, so that vast numbers of people, even as Trump says, even people who hadn't even thought about voting before, get them to vote. And we're going to understand there's going to be an awful lot of people that are going to be voting that don't have a college education, don't in fact live on the East and West Coast, don't necessarily agree with you. And you're going to come to a point where people are going to start wondering whether or not they do want everybody to vote. But I think we have to be very careful about that. We want everybody to vote. We want everybody to have access to the truth. We want everybody to be aware of what the facts are. And all we can do as liberal and progressive people is we can try to share the truth as we know it and use the special talents that we've developed over the years to organize and mobilize the people and assist them in getting their views expressed and brought into law. And so then we'll end up basically exercising state power. And we have to be very careful to exercise state power in a way that protects the rights of all people. And above all, the First Amendment rights to freedom of expression. The key is that if you allow government into that realm of starting to cut back against or regulate the press people, the freedom of press or media at all, the history has always demonstrated that government institutions will in fact start asserting that power in a way to protect those that are in charge of the governing structures. And that usually ends up being the aristocratic elite that are actually running the government. And so that there has developed this kind of peculiar counter-elitism. Ben Bradley is kind of a classic example of that, and Katie Graham. That they talk about having this kind of special responsibility at the Washington Post to criticize the government, et cetera. There's some of that really goes on. I saw that when I was sitting in the original meetings with Jim Goodell, who's general counsel for the New York Times, when they got their hands on the 47 volumes of the Pentagon Papers, to actually be sitting in the room talking with him about, well, what are we going to do with these papers? And what had happened is it was clear that there had developed such an attitude among the people in the United States against the war that those that were the elite that were in charge of the New York Times felt compelled to do something about it, because the disruption that was going on in the country was really threatening the ruling class. that they were part of. And so that what they were doing is they were weighing in to rein in the executive branch that had basically gotten so far out of control that it was lying and conniving and shipping drugs to pay for massive assassination programs and stuff all through the Southeast Asia. And so the New York Times Board of Editors actually, as part of that elite governing circle, weighed in and cut back against them. That's clearly what I saw happening there at the New York Times. Now, there were other newspapers that could have gotten them and published them, but they wouldn't have had the ability, perhaps, to fight back against them. If local Waterloo Journal, had gotten the 47 volumes and started publishing them. I mean, Mitchell, Attorney General Mitchell, probably would have sent in the FBI to tear them out of their office and burn them to the ground, and nobody would have been able to do anything about it. So there is some advantage to some of these larger media groups kind of having some competitive power against the elite that run the government. And so I've seen it happen, both at the Washington Post and the New York Times. So the question is here whether or not through technological ingenuity and the garnering of some resources and other groups, we can generate alternative sources of media, and I think we can. I think that there's a lot of the young people that are in Silicon Valley right now, they can bang together a broadcasting station where they could rival hitting into the people around the world and getting information out. I think we could. So I'm not over worried yet about Google and Twitter and all these things. I think that there's going to be some competitors that are going to be able to arise. For example, MSNBC was able to do it. The Air America didn't work. Trying to get on the air to compete with Fox News, but clearly MSNBC now is comparatively competitive with Fox News. And so that I'm not a great believer in the old invisible hand of Adam Smith and free market capitalism and all that, but I do believe that this free marketplace of ideas that has been referred to earlier is a real deal, is a real thing. And there's a certain kind of power that comes with telling the truth. And there's a whole lot of bullshitting going on all around right now. And so that to be the voice of truth will attract attention and will attract bad guys coming after you, but it will attract good people too. And that's part of what we do at the Romero Institute, is we're trying to become a voice for truth, honesty, fair balance in our analysis of things. And so that I think that, that those of us who are concerned about positions that may be taken by Google or by Twitter or anything else, that if they get too far out of line, we need to organize and generate competitors to them. Okay, gang. Look,
Danny, you want to just say a final thing, and then we'll open everybody up to say goodbye?
Sure. Yeah. No. I think this is a good, healthy discussion that we're having here tonight. I do think that this issue of the freedom of speech on the internet and the ability of the federal government to try to get a handle on it and to take it over and restrict what's being said and what's being done on the internet is an extraordinarily important issue. In that the fact that the people who are questioning some of the kind of verities having to do with the pandemic and the rates, the fatality rates and the other things are being shut off from being able to discuss that at all is a warning sign that we in the progressive community need to be very careful about falling prey to the same type of temptations that we see on the part of a governing elite to silence the people that we don't happen to agree with, and are retreating into a firm conviction that what they're saying is just untrue is not any solace to that, because the ability to ascertain in a time like this what's true and what isn't true isn't all that easy. And so the more open discussion we can all have on it, and the marshaling of respective factual information, I think needs to be encouraged. Okay, kids, I appreciate
Okay.
that. All right, guys, thank you so much.
Bye. Thanks.
Happy
Thank you so
Friday, you
much.
guys. Thank you.